Welcome back, friends, to Terraverse TV. It's John Altarelli, and we're going to do another session today on the Bill of Rights. We're going to cover all the amendments, but we're doing the first 10 to start. We're going to be on the Fourth Amendment today. Very important one about searches and seizures. It's something that is very important to all Americans. It's a very complicated case law on this, so there's so many cases it would take a full, session or classroom session for a season or semester to get through them all, but I'm not going to do that. I'm going to try to synthesize you down to something that you can understand, and hopefully will pique your interest to keep on top of these rights that are important to you. Before we get started, let's just let you know Jen is back on. Jen is back on with us, our producer. I convinced her to get back on camera because I need some help sometimes to prompt me. She also handles all the technical work in the background and a lot of the research, so thanks to Jen. Now, before we get started again, we'll do our typical, please, if you like the content, subscribe, hit the like button, hit the bell for notices and updates, share with your friends, and most importantly, if you have something to add to the conversation, please provide some comments, try to be civil, and if you want me to provide other topics, I'm happy to try to cover them. And if you think that we should do more or less with respect to how these segments go, I'm also willing to hear that. So let's get started. Let's shoot right to the text of the Fourth Amendment. As I mentioned in prior sessions, that this is part of the 10 amendments that were part of the Bill of Rights that were ratified in, I believe, 1787, after the Constitution was ratified, because the Federalists and the Anti-Federalists were fighting over whether or not we actually needed to enumerate these individual rights into the Constitution. There was a concern back in the beginning when James Madison was basically the author or the drafter of the Constitution. He felt that we didn't want to enumerate rights because if we do, then people will think these are the only rights, and really the Constitution was supposed to be such a limitation on government, which most people probably don't realize that's what it was all about. And because if you look at today, how big our government has grown, you'd wonder whatever happened to the Constitution, which was supposed to limit the government. It was really about giving the power to the states and the people. So Madison did not believe that we needed to have these. He thought it would be confusing. It would actually limit our individual rights, and he was against it. But another guy named George Mason from Virginia, who refused to sign or ratify the initial Constitution. I think there was 3 people that didn't do it, 3 states. Did it because he wanted the Bill of Rights in there. He was very, very adamant about it, and eventually he prevailed. And in fact, most of the Bill of Rights comes from the Virginia Declaration of Rights in 1776, which most states also had their own constitutions at the time. Because remember, this was a confederation of states. It wasn't a federal government. It was very reluctantly become a federal government. It was really states who are going to work together as a cooperative federal system. And people forgot that. Now, the federal government has so much taken over every aspect of our life and over every aspect of the law. It's hard to even imagine that states have any rights. And in fact, though, the Constitution made it the states were preeminent over the federal government for the most part. We'll get into that with the 10th Amendment and some other areas when we cover that down the road. Let's get back to the Fourth Amendment. So I'm going to read it now, and this is straight out of the amendment. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, this sort of came out of the colonial experiences where the Brits would come in and they would conduct these things under writs of assistance. They could come in and search your house, do whatever they wanted, and they were very, very bad about that. And the colonists certainly were done with having the government come into their houses. The person's home then, and as it should be now, although we don't have the same level of protection, should be sacred. It's your place. It's your personal space. You should be able to do whatever you want in that house and be free from government interference. That is not the case anymore. Those rights have been eaten away over time, but nevertheless, this is what the founding fathers had envisioned. So So this came out in, let's see, the Bill of Rights, I guess actually was in 1791. The Constitution was 1787. So it was 4 years later that it was ratified. So let's get to the core language. We already covered the core language. Let's talk about what does that really mean. So basically, in order to get a search by the government, and it was a later case, which I'll explain later, that also included the states, not just the federal government. If the government wants to come in and search or seize your property, they have to have at least 2 or 3 things. One, they have to have a probable cause. And second, they have to be able to specify, this is with respect to getting a warrant. This is for a warrant search, not a warrantless search, but a warrant search. They have to specify the place, the person, or things to be searched or seized. And this has to come from an independent judge. So some third party, not the police or not somebody involved in the case, has to decide whether or not the suspicion is reasonable and whether or not they're specific enough. And you'll see this come up. You know, there was a big issue about this in sort of the Trump case down in Florida, where he had the secret documents. There was whether or not they had particularly described that correctly or not. This comes up a lot. So for lawyers, this is something that you look at to see if the warrants were correct, whether they were too broad, whether they took things that were outside of the scope of the warrant. This is what litigators and lawyers do to all the time. Now, there are exceptions to the warrant requirement. And those exceptions are if the person who is being searched consents. So you'll notice almost all the time you look at these video clips on YouTube where people or cops will ask you, oh, can I look at your car, make sure you don't have anything in there, you know, if you have nothing to worry about. That's typical cop talk. You know, they're always trying to get your consent, because once they get your consent, they can search. And they'll do anything they can to try to get your consent. So if you're in a situation where you don't want the police or anybody else coming in and searching your place, you just don't consent and make them get a warrant. It's not that easy to get a warrant. And if they get a warrant, then of course you're going to have to let them in. But in the meantime, I would say it's not a good idea to consent. It's never your friend. I hate to say this, I have a lot of law enforcement friends, but frankly, they're trying to get evidence on you. And whether you're in trouble or not in trouble, I recommend against it, because you are almost never going to come out ahead in the battle with law enforcement. So I would recommend that you enforce your Fourth Amendment rights whenever you are faced with that challenge. It is your right. You don't have to let them search. Let them get a warrant if they really believe they have probable cause. The second exception is in plain view. So if they're looking, you open your door and the cop's looking in there, and you've got a pile of drugs sitting on the table and money and guns and all that, and they can actually see it when you open the door. Well, you now left it in plain view. They have the right to come and to both search and potentially seize. Same thing in your car. If the cop can look in the window and he sees you've got a gun or some other stolen item or drugs or something like that sitting on the seat, and they can see it while looking in your window, that's in plain view. They can search. They don't need a warrant. The next one is just vehicles in general. If you get pulled over in a vehicle, they don't have the same expectation of privacy. And we'll get to what that expectation of privacy, where that crept in. It was under a case, under the Katz case, and I'll explain that to you in a minute. That means that if you don't have an expectation of privacy, then you don't have the right to protect that against an unreasonable search, or let's call it a search and a seizure. Your car is not given the same amount of protection as your house, although there are things about your trunk and your glove box and things that are outside of plain sight. But if they can see it, they can search it. So, a couple of things happen when you get pulled over. Lots of times they'll ask to search the car, for drugs or weapons. You don't need to consent to that. And I wouldn't consent to that, because you never know what the agenda is of these police officers. And sometimes they actually do and have been caught on numerous occasions planting drugs and paraphernalia and things like that in a car when they want to try to arrest you. Maybe they think you're guilty anyway, but they don't have the evidence at this point. They want to just make sure they get you. So I don't know the motivations. I don't think most police officers should be should be concerned that they're going to do that, but in fact it does happen, and therefore it is your constitutional right not to consent to the search. However, if they see something, they can. And if they need to stop the vehicle and get a warrant, they can stop you until they can get a warrant, because the problem with the car is that you can drive away with the evidence, so they give the police a little bit more leeway here to prevent the evidence from leaving the scene. The other thing that they can do in a vehicle stop, which is, I think it's state by state, but for the most part, if they bring the drug dogs and the drug dogs walk around the outside of the car, they're not searching the inside, but if the dogs alert to drugs, then that is reasonable for them to go ahead and search for drugs. So that's another thing you got to watch out. If they get a dog around your house or your car, and they try to claim that they smell the dog's alert, then they're going to be able to search you. A lot of times you'll see police officers just saying, "Oh, I smell it, therefore that's going to give me the right to go in there." That's probably something that's on the line, but I would suggest that it has to be a dog, although the police are very good at convincing you that they have the right, and therefore you may end up consenting when you probably should not. I would just take the view, again, I'm not trying to harm the police officers, my good friends that are police officers, I know they have a tough job, but at the end of the day, these are constitutional protected rights, and we should enforce them. And if that means sometimes people get away with smoking weed in the car, even though it's legal now, then too bad, that's what happens. I don't think we should abridge these rights just to be convenient so that the police have an easier way of finding lawbreakers. We don't want to make their job too hard, but at the same time, we can't make it so that we give up these very fundamental rights, which were hard fought over, and they're right to have these rights. You should be able to have some expectation of privacy in your person and effects, particularly in your house and in your car. There's another thing called Terry stop. This is from a case, Terry versus Ohio, where they had these sort of stop and frisk rule. This has been a very controversial provision. It's been claimed, and probably there is some statistical evidence that it's been used more. They've been used more against African American and Hispanics than they do white guys, and this has been a big bone of contention with most of the claims around police racism and brutality and the like. Terry stop is one of them, where you can just stop someone, and you don't have to have the same level of probable cause as you do for a warrant. It's called, you have to just has a reasonable suspicion of some kind of crime having been committed, being committed, or about to be committed. So that's the rule. This thing called reasonable articulable suspicion. So you have to actually articulate it. You have to be reasonable based on the circumstances. That all can be reviewed by a court, and they have to have suspicion of some illegal activity. Now, you'll see a lot of clips on YouTube, and I always laugh at them because the cops will say, "Hey, I got a call about a suspicious person." Well, a suspicious person doesn't mean anything. Suspicion is not a crime, okay? They have to be suspicious of a crime, and the police often are not trained, or if they're not trained, they're doing it on purpose, is not to articulate what the crime is. Is the crime trespassing? Is it whatever it is? It has to be something. If you're just standing around in the street and you look like a suspicious person, by the way, I probably look like a suspicious person as well if I'm hanging around in the street at the wrong time of day, wrong time of night. But if I'm not doing something, if I'm not out there like opening up car doors with a hanger, or I'm not like peeping Tom in someone's window, I'm not committing a crime. Suspicious, who cares? And a lot of times police will use that, and they'll say, "Oh, suspicious person, we got a call, or we got a call about a black guy, who robbed the bank down the road, and you happen to be black." I mean, that's very difficult to get from a black guy robbing a bank to a black guy standing on the street corner, doesn't have a gun, doesn't have a bag of money with him, and say, "Oh, well, you're black, so therefore, we have reasonable articulable suspicion that you've committed this crime." And that's a fine line, and it's really tough. And sometimes the police actually do have a reasonable articulable suspicion of someone who is driving the proper car, dressed like the person that they've been identified, and all that, and that will sometimes lead it to be reasonable if enough of the description matches the particular perpetrator. Then I think the police have RAS, we call it RAS, to detain that person to determine whether or not they are the person who is suspected of a crime. So that's a fine line, but that's another situation. And there's one more that's not quite codified in all of this, but it's, there's enough cases on it. It's what they call exigent or emergency circumstances. So if I am a cop and I come up to the door and I'm on a domestic violence call, which is typically these poor cops, they get a lot of those, right? There's people fighting, there's yelling going on in the house, and now the person who called in doesn't want to turn on her man who's beating her up. It's really tragic. It happens all the time, and but yet the cop does see in there, hey, he sees someone getting beat up or he hears, a scream. I mean, he may have no choice at that point but to go in without a warrant. So again, it's all facts and circumstances. There's a lot of judgment here. We've seen, and Jenna will attest to this, we've seen police actually kill people in these sort of circumstances. They get nervous, whatever, and they pull their gun and end up killing a person who wasn't armed. It happens. It's not rampant. I mean, the numbers are not nearly what people think. They're much lower than that. I mean, they're incredibly low, actually. Just that whenever it happens, it becomes national news and it becomes a real issue. But nevertheless, it's a tough call. It's a judgment call by the police officers, because at the same time, they're there not just to find criminals, but they're to protect and save. So if they're there trying to protect someone's life, they're going to have to use their judgment, and it's not easy. And again, that's the good thing that we have courts and systems to look and review these things, and hopefully that in most cases, and particularly with all the emphasis today on scrutinizing police behavior, I think you're seeing more and more of that scrutiny. Actually, in some cases, it's actually over the top. I think they've actually probably gone the other way on some of this, and some of the police may be convicted of things that they probably shouldn't have been. But nevertheless, this is clearly an area that's under complete scrutiny now, and it needs to be, because I think these things probably got covered up more than they should have been in the past. Police were probably given too much deference on these issues. So now I think it's better, and I hope that we continue to do that, but I also don't want to see police officers subjected to jail, or even good Samaritans. We had a guy in the subway that stopped a crazy guy from attacking the patrons, and he ended up putting a chokehold on him, and unfortunately the perpetrator died, and he's up on a murder charge. So it's really difficult. It's a difficult judgment call, and if you're out there in the public and you get involved in something like that, it's hard for me to tell you not to be involved. I know if I'm there, if I see someone being hurt, I probably don't have the ability to stop myself from intervening, and I'll probably suffer the consequences, whatever they are, because I'd rather save someone's life or my own life and worry about the legal consequences than do nothing and see someone get killed or myself get killed or harmed or somebody in my family. I'd rather face the legal system and hope it works, but it doesn't always work. So now let's cover a few of the cases that are important cases. So I think I talked about the Terry stop, which was Terry versus Ohio, and that's where you had this stop and frisk rule and where this reasonable, articulable suspicion standard was established. And it's not the same as the normal warrant standard, because it's supposed to be, because it's sort of a emergency situation. The person that you need to see is right there, and then if you don't stop him, he's going to be able to walk. You won't be able to search him and all that stuff. And along with that, you get to you get to pat down on someone, right? So you can make sure that they don't have a weapon on them. So you can do an exterior, not like a full-blown search, but you can pat down and make sure they don't have a weapon with them. So, and of course, the police sometimes will go farther than they're supposed to, but again, that's something that they do have the right to do. So that's important. And the same thing that comes in here, but it's not really this, is about identification. You'll see a lot of these videos on YouTube where the police try to identify someone who hasn't committed a crime, there's no reasonable articulable suspicion of a crime, yet they want to identify him. Of course they want to identify him. They always want to know who was there at the scene, because if something happens, they can say, hey, oh my God, that was the guy that was there, And it's not crazy for the police to do that, but at the same time, you're not required to identify yourself. In a traffic stop, you are. So make sure there's a difference between traffic stops. In a traffic stop, they can ask for your license, registration, and insurance, okay? And you have to provide that. You don't have to do any more than that. You don't have to talk. You don't have to answer any questions. You don't have to consent to a search. All you have to do is provide that information. And that's all you should do. You should shut up after that. You should not answer questions, because oftentimes what the police do is they'll ask you a bunch of questions trying to lead you down a path of incrimination, like, have you had anything to drink? Where are you going? Where are you coming from? What were you doing? And all these things can be used because you now are giving that without being detained or arrested, and you're not yet subject to the Miranda rules and all that, so you don't have the right, to have that protected. So don't answer. Let them arrest you and let them read you your rights, which they're not going to do unless they really have something. But oftentimes they're on a fishing expedition, and it's not because they're bad people. It's just because they're always trying to make sure that there isn't something going on. They're suspicious by nature because they normally don't pull you over unless there's something. They normally don't get a call unless there's something. So I don't think they're out there searching, out there as much as people like to think that they're out there just trying to get people. I don't believe that. But anyway, so that's the other situation. So that was the Terry case. The Katz versus United States case, it expanded the coverage to include conversations and electronic surveillance. So it wasn't just person, places, and things, it's also communications. So that was clear. So you have an expectation of privacy. So wiretaps and those types of situations, those require a warrant. In other words, to overhear your conversation when your conversation has a reasonable expectation of privacy. If you're out talking in public, obviously you don't. If you're on your telephone talking to your family member or neighbor, you do. So that's important. And of course, that thing, you can get a warrant for a wiretap if you have the proper probable cause and specificity, and they do. You've heard about all kinds of wiretaps in many, many cases. So that is available, but it just requires a warrant. The other one is MAP versus Ohio. That's where they took the Fourth Amendment, which was not considered to be applicable to the states, and they made it applicable to the states as well as the Fed. So that was what MAP Ohio was a very important case as well. And again, I think I went back on the Katz case. I just want to make sure that people understand that's where that sort of phrase, reasonable expectation of privacy, came from, because even a person whose communications, while not a person, place, or thing, doesn't squarely fit into the language of the amendment, the courts have interpreted that to be covered as well. They interpret it to be as broad as possible, which is what all of these amendments were supposed to do, was to protect individual rights as broadly as possible. And we talked about Terry, we talked about MAP, and then there was two later ones which are kind of important, which sort of set the tenor of where this is going, because as technology changes, there's more ways for them to surveil you, right, than they used to have. So now you've got GPS trackers. So there was a case called U.S. v. Jones where they said a GPS tracker put on a car, that violates the Fourth Amendment. And then there was another case, Carpenter in the United States, where they said cell phone location data was also a violation to collect that. So all of these things have been litigated, and they're all, then they're going to keep coming up, right? Because you've got your text, you've got all these different technologies that are going to come into play here that were not specifically covered by the plain language of the Fourth Amendment. But the court cases have so far pretty consistently led the way with protecting those rights, just like they have persons, places, and things. Now I want to talk about, as we wrap up, that's probably a pretty good high-level coverage of the Fourth Amendment. There's a lot of detail there. There's lots of exceptions, but to start with, those are the sort of broad strokes on the Fourth Amendment. Now, there's been something going on recently, and it's gotten even worse since 9/11, and that's there's an act called it's called FISA. So it's the Foreign Intelligence Surveillance Act, okay? And this was enacted in 1978, and this was intended to deal with trying to surveil foreign actors. So it's people who are not U.S. citizens and their actions outside of the United States. So they're not in the United States. And this was all about trying to prevent terrorism and sex trafficking. But it was mostly terrorism and acts of terrorism, okay? And this is what this was all about. And the way they were doing it, they were tracking sort of foreign agents, and they were tracking terrorists all around the world, but not in the U.S. Then after 9/11, they amended it to broaden the scope of that. And now they could actually track even conversations between people in the U.S. and those foreign persons who are under surveillance. And unfortunately, that means that they could be U.S. citizens. So it's not limited no longer to just foreign citizens. So if a U.S. citizen happens to be talking to a foreign person, and they're talking from the U.S., that will get picked up oftentimes by a FISA search. And then later on, something comes up in those conversations where they see some other type of criminal activity and they think that maybe that U.S. person is involved and they want to use that evidence against that person. That's their issue, because under the Fourth Amendment, that would not be allowed absent a warrant. And the warrants under FISA are much different than the warrants that you get for a typical search. So the standards are lower and they're different, and therefore you are more exposed under that statute than you would under your normal Fourth Amendment. And recently, that act was extended because it had an expiration on it. It was extended recently in the last Congress. And the Republicans tried to add some limits around that to force some warrants, and it didn't get passed, unfortunately. There wasn't enough on either side of the House, frankly, to get it done. And therefore, that's now even further expanded. And so this is something I'm very concerned about. I'm not a fan of this FISA searchless surveillance. I believe that if it's an American citizen, you should get a warrant. I believe any information that is brought in that is not subject to a warrant should be excluded. It can't be used against you. And we've seen where it has. It has been used politically. Okay, they had Trump under a FISA surveillance. They used it against him, and they'll use it again. And I think it's not a very good law the way it's being expanded and applied. And I'm going to do a separate session just on this with a law enforcement professional who is an expert on this, so that you can get a little bit deeper into this and why you'll find that I think my concerns are valid. Not only that, because the FISA warrants are secretive. You know, they have a special court that hears them. You don't even know about them. You don't even know there's a warrant on you. And the probable cause standard, as I said, is less. So that's my concern today with the Fourth Amendment not being as strong as it should be. I think most of the other cases have come out relatively okay. I'm not against sort of the car and some of the things that the police have the rights to do without a warrant, but I am concerned about the FISA ones, because I think they're going to be abused, and I think they are being abused, and I'm worried about that. So that's something I hope that Congress comes back to revisit and make sure that they're not surveilling U.S. citizens, because, by the way, the law was not intended to cover U.S. citizens at all, and it's morphed to do that. I think I read somewhere in the congressional hearing, I heard on it, that it was like over 200,000, warrantless, surveillance on American citizens. Some really, really large number. I have to go back and look it up. It was a big number, and it was shocking to me that could go on, and no court actually approved that stuff. And it's clearly, on American citizens that I have no reason to be surveilled, but they're being surveilled because somehow they're talking to somebody from a foreign country that may or may not be involved in some other type of activities. So that's sort of the wrap up on the Fourth Amendment. I hope that was helpful. And if you have any comments or questions, please put them in the comments. Again, like, subscribe, hit the bell if you want more of this. I want to thank Jenna again for putting all this together, helping me get these things out there to you. We'll do the fifth, maybe the fifth, and we might do a couple of these together, because some of these amendments actually work in tandem, and they're important to put in tandem. So I think we might even do some where there's just more than one amendment. But the fourth, I think, is a pretty good one to do on its own. So hopefully that was fun. We'll see you next time. God bless. Be safe. Take care.